Good morning, Chief Justice.
How are
Good morning
you?
to the commissioners. I'm fine, Chief Justice.
And how's your aunt?
Oh, she's well, thank you. Thank you for asking.
All right, you've been here before, so
Certainly, Chief Justice.
you have an idea how this goes.
Yes.
And you won't be as nervous as someone who's never undergone this process.
Absolutely, Chief Justice.
Okay, you have 3 law degrees, 2 a BUris and LLB from the University of the Western Cape,
That's correct, Chief
and
Justice.
an LLM in labor law from UNISA.
That's correct, Chief Justice.
You came through the ranks of the NPA,
That's correct, Chief Justice.
started there in 1999,
That's correct, Chief Justice.
and rose to the position of senior state advocate by 2007.
Correct, Chief Justice.
And then what happened? There seems to be a gap according to your questionnaire, because you joined the bar in 2009. What did you do in that intervening 2 years?
2008, I did my pupillage, which I had to do again in 2009.
All right. Then you joined the Cape Bar,
That's correct, Chief Justice.
and you've been with them since.
I've been with them until 2020, you'll note, Chief Justice, 22. Let's see where we are now. Yes. I'm now with Papasa,
Oh, I
practicing
see.
in Cape Town.
And you focus mainly on criminal work, you say,
At the beginning, yes, that's correct, Chief Justice, but
or have things changed?
well, since working with a state attorney, I've mentioned you get various briefs, at least civil matters from the various departments, mainly your Minister of Police matters, a little bit from the correctional services. Yes, so it hasn't been just criminal matters.
Okay. But still, the only civil work you get is from the state attorney.
That's correct, Chief Justice.
You started acting in 2016,
20,
was it? Yeah, I think it was in 2016, your form says.
yes. Yes, 2016.
2 terms then, another 4 terms in 2017, another 2 terms in 2018, 3 terms in 2020. And then you interviewed for a vacancy in this same division in 2021.
That's correct, Chief Justice. I seem to have, if I may just be given a moment, I want to highlight. I've noted perhaps on paragraph of the Form 9, I'm trying to get it on your bundle of documents. I think it's on page, oh, it's different. The application, okay. But I've missed out 2016 and 2017, the 3 terms and 2 terms. In the application form, I seem to have only stated 15, 16, all right, no, there it is, 17 and 18.
Yeah.
Yeah.
So how many weeks in all has that been?
When I calculated, it comes to 72 weeks,
72 weeks.
standing on being corrected. Maybe
Have you had further acting stints since you interviewed in 2021?
I have not had the opportunity, Chief Justice. I probably will address that, but I have requested, but I will address that perhaps with the acting JP. But I have requested.
All right, and you were not invited?
I was not invited.
Okay. What kind of matters did you adjudicate during these acting stints?
Variety, Chief Justice. Wow, it was such an exciting period of my life because I was at the time exposed to civil. You would do your criminal, which is what I was used to, but you would be thrown at civil, you'd be thrown at motion court. Sometimes I remember in 2020 I had to do 2 weeks of motion court.
How did that go?
It went well. Chief Justice, you you get used to how to run your motion court, you know. I think, and the reviews I would get from the practitioners who appeared before me is, you know, they enjoyed my you know, sitting as a presiding officer in the motion court. You know, they expect that I studied all my files and I'm ready and I'm proceeding with the matters as expeditiously as I can. So I did enjoy, learned a lot, because you have to, it's either you sink or you swim or sink.
Were you able to produce any written judgments?
I have, Chief Justice, when I calculated, I might be wrong again with the numbers. Written judgments since, during the period of my acting, since 2015, close to about 200. Some I've noted on my application were taken on appeal. I've had some are upheld, partly upheld, and I think one that I could recall, which I've put in my form, was set aside. So I've had that.
You did mention Boanya,
Yes, that's correct, Chief Justice.
but you said it was upheld, which is not entirely correct.
No, Boanya, a unanimous majority decision.
All right.
As far as, if you want me to talk about it now?
No.
You would, sorry, Chief Justice?
I'll go and check and we'll come back to it later.
Yes, Chief Justice. Sorry, I'm looking at the bundle of documents and I have my own file, so I don't want to,
What are you looking for?
I wanted to check about what you said. I've said that Banya was upheld.
That's in page 13.
13?
Okay, I'm looking at
No, no, my 13 isn't.
yeah, it's at page 26, but
Okay.
let's put our finger there, we'll come
Yeah,
back to
we'll
it.
come back to it. Thanks,
Yeah.
Chair.
So how long did it take you on average to produce your judgments?
Average, when I checked, is just 2 months. I've had one or two which went about over a week, another one about a day or so. But the average is just 2 or just over 2 months.
All right. Well, you said you may want to discuss this when you questioned by the acting judge president. But I just wanted to ask you, you interviewed in 2021 and you did not go through, and I remember vaguely that the feeling would have been that you were not quite ready. And now you say you have not acted since. So I want you to tell us what you have done in the intervening period that would have, patched the gaps we would have been concerned about when you appeared here before.
Thank you, Chief Justice. I wasn't sure exactly. We don't get obviously the privy to the reasons for not being accepted, but I take your point. Chief Justice, since then, I have obviously, when I spoke with the AJP at the time, requesting to be invited again, I have worked as a disciplinary hearing chairperson in the Department of the Premier's Office. I was appointed for a period of a year since 2023. It ended, that contract ended now in 2024 in May. So I've been writing the awards, running the proceedings, and I've had a lot of those. Chief Justice, I've further been in the panel again for disciplinary hearings for the Legal Practice Council. And there I got also to scribe some of the decisions that we took as a panel in review applications or in challenges to any decisions that are made that the legal representatives or any party that is rather making allegations against the legal practitioners. So I've been writing as well from that space. Yes. That is as far as I can take it, Chief Justice.
Okay. The GCP takes issue with your judgment writing.
That's correct, Chief Justice.
What do you have to say for yourself?
As I've said, I think before, Chief Justice, criticism is good, it humbles one, but in my view, I am open to being obviously trained further. We do not come with the expertise when we come, especially in this profession. Some of us have not been exposed or at least been privileged prior to even venturing in coming to this, to the bench to really utilize your drafting skills. So mine is to say, I am ready and open to being trained. I think an ongoing training for any judge is something that should be recommended. The commissioners must look at all the other requirements as far as my suitability for the candidacy. They should not use simply the fact that there is an issue with, they think that my judgment writing is an issue. I think one of the matters that they highlighted, I would like to also answer that those judgments went before senior judges. One of the cases, Poanya, went before the Constitutional Court. Unless I missed anything, I did not hear the judges are taking my judgment style or writing. It went, one of the cases also, if I recall correctly, it's been to the SCA, Chief Justice. So what I'm saying, whilst I'm not, standing on the way of being trained, I do appreciate their criticism, and I would ask the commissioners to also have a look at other requirements that are required for this position, and also the fact that I have a teachable heart. I do state that, yes, I'm a fallible human being. I have my own weaknesses, which I'm open to be, that they be strengthened.
Have you undergone the aspirant women judges training course?
I have prior to my acting stint in 2015, Chief Justice, July, we had Justice Majid at the time who was training us. The opportunity
in 2015?
Yes. Chief Justice, I think it was 2015, not 16.
You have not undergone the advanced one?
The advanced one I have not. I was invited last year, Chief Justice. And Chief Justice would recall when we were called, when we got the invitations, and then we were told somewhere along the way that now we must pay for our expenses.
Or
which
is
I could
that
not
what
afford.
discouraged you?
Yes, I could not afford at the time, yes.
Yeah, but that's something we are working on and hope to fix. Otherwise, the whole program is sunk.
Yes, I'm afraid so, Chief Justice. It's good to hear that is being considered.
Yeah. Okay. I'm going to hand over to AJP Goliath, if she has any questions for you.
Thank you, Chief Justice. Advocate Magona, I have observed your whole profile and your growth as an advocate.
Thank you.
And I can commend you because I can see the growth.
Thank you,
How you
AJP.
have grown, I can see that. So whatever I'm going to say to you or ask you, please don't take it in a negative light, because I am alive to the fact that you have grown and you have moved on.
Thank
and
you,
that you
AJP.
are a person with potential. Now, when you acted in the division 2016, 2017, and 2018, the Judge President and I, as well as some colleagues, were of the view that you did not do well in terms of the quality of your judgments, and even your reserve judgments. Do you have any comment on that? That this is old news. That's why I say don't look at it in a negative way. But 2016, 2017, 2018 did not go well for you. Any comment on that?
Thank you, Chief Acting JP. It's my first time I'm hearing of this, Acting JP. I do wish that you had informed me perhaps prior, and I would have expected then that maybe you as well as the JP then would
That's
have
correct.
assisted
Both of
me.
us.
Yeah, would
Yes.
have assisted me where I was weak on. So just caught off guard. I've written a lot of judgments at the time. I would have prepared for this question also on time. I've written a lot of judgments at the time. I really never had any negative comments from your side. I do think,
No
HAB.
problem.
I do think that obviously my writing style got better, and I'm sure, well, I have not heard if there was any written complaints to your side about that. Again, I'm open, HAB, to fall under the training. I understand the systems are there currently that are being taken care of
Yes.
by the division for the acting judges, as it should be. I am certainly open to that. Yes, that's what I would say to that.
Well, during that period, I was appointed the DJP in 2016, so I can assure you that the Judge President and I had discussions regarding the competencies of the AJs, but that is in the past, because I have indicated that I can see that you have made efforts to grow.
Thank you, HAB.
Now, you indicated that you've written quite a number of judgments, even though none of them are reported. You've written a number of judgments, right?
Yes, HAB 1 is reported that I could pick
Oh.
up. Bwanya is reported.
I see.
Bwanya is reported. Well, the others, your SCA ones, which obviously are not mine, but are
Yes.
reported by the SCA. Yes.
So you have annexed 3 cases. The first one I see it's a summary judgment application. The second one is a stay of proceedings, and then it's Bwanya's case. But leave Bwanya for a moment, because it appears as if that was quite an important judgment that you wrote, and the Constitutional Court ventilated the issue. So I'm not talking about that case. I'm talking about the 2 cases, the summary judgment and the stay of proceedings. I would have expected you to impress the Commission with more complex judgments as a summary judgment and a stay of proceedings now that you have the opportunity to do so. Was this the best that you could present?
Chief Justice, when I made the decision to apply again this year, it was very late. And obviously, colleagues were encouraging me, and I thought, maybe next time. So when I collected my judgments, I discovered I do not have the copies of the signed judgments. I have my drafts, which would not be suitable to present before the commissioners. And I also discovered that most of the time between 2015 to the 2018 period, we were delivering judgments. You would recall in person, we would go in court and have them delivered. Parties will be, copies of judgment will be disseminated to the parties. So I couldn't. Now I could recall, after I've submitted my application form, I'm preparing, then I looked, my goodness, you have, complex matters that you dealt with. I had a matter that had fishing rights that I had to deal with, constitutional issue. I had a matter, Bwanya, I've submitted. I had other matters I should have, handed in. And I still didn't have the original judgments, and I was trying to trace them. Lastly, just last week, I was speaking with one of the senior judges, because I said, I don't know if they will accept, but is there any way that you have this copy? This is one of them, but I couldn't hand it up before the commissioners. It was too late. I didn't want a burden. I didn't want any special treatment. I could only get, and I'm grateful to, it was Judge Ndita. I was with her on the Viking matter, one of the full bench judges with Judge Klute. So she said she will see what she can do. That was last week, and she could only assist me yesterday in the afternoon. I thought there's no way that I can. Now I had that written judgment. That's the one that deals with the little bit about the fishing rights and what was happening at the time. The Marine Living Resources Act was being challenged, the policy. So that I would have handed in. I did look at oh my gosh, I should have done better. But I didn't have the copies of the original documents or the judgments, AJP.
So you returned in 2020?
That's correct.
Was there any difference between the type of cases you did 2016, 2017 and 2018 and when you came back in 2020?
No,
in terms of the complexity of the matters, etc.?
Absolutely. I think there was. I grew a lot. If I may just... I did a lot of motion court, urgent applications of various matters. Some I had to write judgments on. The complex matters which I dealt with, I recall a lot of matters involving interdicts, but the issues themselves, some involved PRASA and the complexity of the issues, the termination of contracts, etc., etc. Some involved building and construction work that was not done. I think your top stores case, which is there, that I got during that period. Some involved, yes, contracts which were held to be contra bonus mores. I think there's a kudu cap matter. I gave just a list. I really couldn't submit the judgment. I think you might have gotten that list on Friday. Listed it there. Kudu cap matter involved some termination of contracts which were found to be against public policy, etc. So yes, to your answer, AJP. I think I was quite challenged, which I enjoyed, and it exposed me to more complex matters.
Your judgment in Banya, I've read the judgment, and what struck me was that in terms of the structure of the judgment, you elected to deal with preliminary issues, the issue of condemnation and mootness, very far down in paragraph 80, paragraph 111 and 116, you dealt with the issue of condemnation. And then further down in paragraph 125, you dealt with the issue of mootness, whereas those issues should actually, it's considered as points in limine, and you identified it as such. Is there any reason why you decided to deal with it so late in the judgment and not as a point in limine and then move on from there? Because ultimately, if a matter is moot, you must say so early and crystallize the issues.
I think mine was to summarize the facts first, to put everything into context as far as where I would be going with regards to those 2 points. Yes, I agree with you, the AJP, it makes sense. Deal with them right at the beginning so that those 2 points are out of the way and then you get to the crux of the issues. But I think it's one of those, again, matters that one needs to look at when you look at the judgment as a structure to make sure that you get to those preliminary issues out of the way.
I'm pleased to hear that you indicated to the Commission that you are trainable. So during my stint as AJP, there were 8 African women who acted in the division, and all of them were sent for judicial training. And I did, in fact, personally recommend you for judicial training, the Sajay training, because I was of the view that you needed further training, more particularly with regard to your writing skills. But you didn't attend that training, and that's why you were left behind.
That's last year's one?
Yes.
Yes, as I've explained to the AJP, sadly,
Yes.
It was the cost effectiveness for me at the time, because usually those trainings, the department would pay for us, but we were informed, I think, weeks before the time that actually we need, all of us now must, So I compared at the time, could I afford it? I couldn't. And I think I actually waited until very late, being a victim of having to wait for 30 days for payment of your invoices at the time. I waited until I think the very last, if I look at my emails, I'm sure the secretaries can check, that last week before Monday, and I'd even started drafting, if you could find on the archives, because I know we had a password as well as access to submit our our judgment. I submitted the assignment, the first one, because I was so hoping that, my invoice would be paid, but obviously state attorney was late. I couldn't afford, but I submitted still my assignment if that was picked up, because I really genuinely wanted to be there. I know this is exactly what I would be asked one day if I were to appear before this commission.
Yeah, that is unfortunate, because had you attended that training, you would have been invited to act in the division just like all the other, particularly women who attended that training.
Yes. AJP, well, I didn't know it would be obviously a requirement. I understand that. But as I've said, I had attended the training prior, not the advanced one. And yes, it would make sense that I would have been invited because it was the advanced one. But AJP, when I spoke with you telephonically to congratulate you with regards to your appointment as AJP, I spoke to you and showed my interest to you. I advised you that, look, this is where I am. I've left the bar, but I'm with Pabas. I recall that conversation.
I recall that
Yes.
conversation.
And I
yes.
requested you to invite me. I'm still available, AJP. And I had expected that, you would, because I know your heart, and I at least would have expected that you would then invite me. Because I think there was a, let me stop there.
There
But
was
you
what?
do, sorry.
You didn't finish your sentence. What?
I wanted to obviously, I had expected, being a female judge, AJP would expect that, and for her wanting to empower, as she's saying, African women and wanting more African women on the bench, and having acted before, she knows me, because I've been there for a number of times with my instance before her. So I had expected that she would then still invite me without having to go to the advanced training. The advanced training would have been a cherry on top, but it would have given me more opportunities to still utilize and harness my writing skill by acting, but that never happened.
Why would the AJP have been obliged to invite you?
Not obliged, there's no obligation. I think just to raise
You
your
had an expectation.
No, yes, perhaps in a way that I should put it this way, Chief Justice, you raise your hand and you are, maybe hopeful that you would be invited. And that never happened. So, yeah, not an expectation. Perhaps that's a wrong choice of word. I was hopeful that I would be invited because I knew I needed, obviously, more time to do a little bit of acting.
Yes, more time would definitely benefit you, but you do understand that I did identify you. I personally recommended you. I was of the view that you could benefit from it, and it appears as if that was then the problem, the fact that you did not present yourself for the advanced training to assist you to strengthen your skills, more specifically in judgment writing. You understand that that became a barrier for you?
No, I don't understand, acting judge president. I could not that I did not, I could not present myself. I was so honored to be invited. In fact, I so much wanted to be there. That's why I said I had prepared my assignment and submitted it, even though I knew I'm not going to make it. I'd already informed the mine would be, perhaps I would answer it this way, AJP. There would still be time to take me on that training, even when I'm a judge. You can, these are ongoing, the training for the judges are ongoing. I'm available to do that. I would ask the AJP to look at all my other requirements to say, if I do qualify, but then let us take you and work with you on this. So that you are not discouraged, demoralized. You are here. You are the kind of person that we do need in the bench. Then internally, you can then take me through the processes of the advanced training courses.
You did not advise my office of the reason why you didn't attend. I'm not aware of those reasons.
AJP, I was only contacted by the Office of the Chief Justice about the training. I was never advised your office that I was recommended by you, I'm sure I would have advised you. So I've been communicating with the Chief Justice Secretariat side. They advised me. They invited me. They're the ones who have been updating me of what was happening. So I thought it would be prudent that I only then communicate with them, because
Yeah, it
that was the
appears,
reason. Otherwise, I would have had no problem
yes.
contacting you.
Yeah, it appears that it's a sequence of unfortunate events. My office did communicate with all those whom I have recommended, and according to my memory, you were included, but I hear what you are saying. You were under the impression that my office was not involved in recommending you, and hence you thought it would not be necessary to convey to me why you didn't attend. I understand what you're saying. That is unfortunate.
IJP, I'm sorry to cut you there. I'm trying to recall if your office ever communicated with me. I really don't have any recollection. I'm not denying it happened, but I really do not have. And I would have had no issues to advise you. I think it's the right thing to do. It's protocol. Deal with the division. If you're AJP, you are the one who advised me in writing that you are on the list, etc. That I would have done without any hassles.
Actually, the procedure is to inform all the candidates when we communicate directly with Sajay. We include the information as well. But look, I don't want to harp on that point. It's just that I need you to understand that I have, in my capacity as AGP, identified you as a candidate. I've put your name forward for advanced training. You didn't attend it, and it appears that there was a lack of communication in terms of the reasons why you didn't attend. I will leave it at that, and I'm not judging you because you are a person with potential. And I did identify you as someone that should be given an opportunity to come back. Now, you say that you are trainable. You are trainable, and you're willing to submit yourself to training.
Yes, AJP.
Now, what can we do better? Because with the Sajay training, I have observed, and based on your explanation, I have observed that the funding is only available to magistrates to attend this training. And it appears as if that was the problem that you had, of which I was obviously not aware. Yes. I thought you didn't attend. I recommended you didn't attend, and you weren't interested, and you've clarified that. But what can we do better to assist people like you who do not benefit from the fact that Sajay only pays for the magistrates to attend that training?
Thank you, AJP. The set period of me having to not attend really affected me. And I was of the view that the Office of the Chief Justice should continue as they were doing before. AJP, you must recall, most of us are, acting and private, independent advocates. And obviously, we depend on our private work as well as the payment system that is flawed. I mean, we can talk the whole day about that and the consequences of it. What can be done? I think, AJP, the times before, I know there were austerity measures, the funding here, funding that. Each department wants to keep some funds, but it must be thought of us. What about us who don't have these funds? We are going to miss opportunities when they come to us. I think the office should consider that there be a budget that is set aside for this training. When the training is coming, I know already, I'm sure there's an advanced schedule of what will happen in the next 2 years, and they know how much it will be needed and how many candidates will be invited. I would propose that there be budget that is set for it, which includes assisting the candidates who so much want to be in these trainings, that they can access it, because the issue of funds, especially for us as black advocates, is a difficulty, and it can be a career and destiny stopper. So I do think that there should be, intentionally, there should be funding. I have nothing against the magistrate, but they are employed, they get their salaries on time, 15th or the 30th, they can afford it, but they're being paid for it. Just doesn't make that much sense. But
luckily, the Minister of Justice is here. You
Minister,
were a
please.
victim of the austerity measures, Ms. Magona. SAJA had every intention of paying the candidates of that program a stipend. And as I understand it, there just wasn't enough money. And it's not just you who fell through the cracks. A number of other legal practitioners who could not afford to leave their practices for an extended period without being on an income suffered a similar fate.
Yes.
So these are the things we keep talking about, and unfortunately, we depend on treasury and all these executive structures for money.
I understand, Chief Justice. And these are the consequences. I think the Honourable Minister now I can understand as I'm speaking it. I missed out the big opportunity, which, and so many others that are here now, that would have benefited me in my professional life. And hopefully in the future, this can be prevented. There's so many young professionals who want to grow in the profession and they can't afford it.
And in this case, we're talking about a division which could do with African females.
Absolutely.
And they are the ones who are worst affected
Absolutely,
by this
Chief
situation.
Justice. Absolutely.
Yeah. I'm glad to have a live example.
Absolutely. I'm here. I am the one.
I'm sorry I interrupted you.
No
AJP.
problem, Chief Justice. I just want to reassure Advocate Magona that the women who attended the course were invited, and it is unfortunate that you were excluded. And I indeed sympathize with you because of that, and the Chief Justice made comments regarding those protocols and policies. Thank you very much, Chief Justice.
Thank you, AJP.
Thank you, AJP. Mr. Boshoff.
Thank you, CJ. Morning.
Good morning, Mr. Boshoff.
Are you well?
Commissioner Boshoff. I'm well, thank you.
Yeah, good. So the Western Cape Division, given its proximity or its location, with the seat of Parliament being in the province, Western Cape government, metros, various municipalities, quite a administrative law is quite a significant, potentially forms the majority of civil work, opposed civil work in the division. So I'm just going to ask you two technical questions on administrative law. The first one relates to interim interdicts, and the so-called Part A and Part B applications, where Part B deals with the judicial review application to set aside let's say, for example, a tender, an administrative decision.
Okay.
And then the tendency now is to bring in a Part A to try and stop the implementation of that tender, for example. Now, you'll be familiar with the requirements for interim interdicts, and the first being the establishment of a prima facie right.
Yes.
Is it sufficient to rely on the right to review, or the right to fair administrative action, or the right to a fair supply chain process as per Section 217 of the Constitution, in order to establish and satisfy that first requirement?
If I understand the question correctly, so we would be looking at your Part A now.
Yes.
And you've correctly stated your setlugelo requirements would have to be there. But now, I think as a court, you must be careful not to stifle the exercise of the Part B power from the executive. You must look at what is that tender about. Whereas there are interim interdict requirements that are there, it must be, I think, in the interest of justice that you can stifle that power, because at the end of the day, if I understand your question correctly, there is public that stands to suffer, or the executive powers that stand not to be exercised or executed that ought to be executed. So It would have to be, you must prove more and rigid facts or evidence to show and convince the court that actually, whilst you're granting me Part A, grant me rather Part A, the interim interdict, whilst we are going to take maybe years to finalize Part B, which is usually the case. So the court must balance that, because sometimes your Part A is not as simple as granting it, and then things are going to happen immediately with Part B. What does happen in some of these cases, and I think one of the cases at the Constitutional Court said you must look at all of these things, that your Part A, if I grant you, sometimes really deterring that power to be exercised in the interim might stifle, obviously, the maybe service provision, in that tender, or anything further that maybe the community needs, in dire need, is maybe water, maybe electricity, etc. So, to your answer, you don't just look at the settlement requirements, but go a little bit further and see if there is any other heavy requirements or reasonable requirements that should be considered.
But are you not now analyzing the balance of convenience in your assessment there? Whereas I'm specifically concerned about the question of establishing the very first requirement, or satisfying that requirement, being what is the prima facie right that you are asking the court to protect here? To protect by way of an interdict? What right, or is it sufficient to say, I am taking this matter on judicial review and therefore I'm entitled to my interdict because Section 33 ensures my right to fair administrative action, or Section 217 guarantees me a right to transparent and competitive and cost-efficient supply chain processes or procurement processes. Is that enough to tell the court, well, we need to look further?
Well, your prima facie right will be a right that you are claiming that you as an applicant is being breached by the administrative action that is being taken or decision that is made. So it can be a right that is, can be easily determined from the facts. At times, as I've said, maybe your access to water, access to your rights from the Constitution, constitutional rights. Sorry, I'm trying to gather my thoughts nicely.
You're on the right path because, in the outside judgment, the court did go about, these so-called clearest of cases where, for example, a community's rights, if the tender is so critical, that it needs to, because there's no follow-up service provider, for example, is in your example, to provide clean water, etc., the court would be willing to then say, look, I'm not going to, I need to ensure that those, things are taken in. So I think let's not take that any further.
All right.
I want to move on to the next question. So-called reactive or collateral challenges. Are you familiar with them? What do you understand in respect of that? And can organs of state raise them in a matter?
No fundi of administrative law, but collateral challenges, I think they have to do with, indirect attack on something that is not about the main issue that is before the court. So you can bring about such an issue before the court because it's collateral. It is not the material issue that is before the court, but the court can, if it's in the interest of justice to do so, can deal with it. Your second one was, can the court, sorry?
Can organs of state raise them?
Can organs of state raise collateral challenges? Let us see. If it's something that has to do, let's say, in your first example, a review of an administrative action, only on the principle of legality. Are you with me?
Yeah.
But if it is, they cannot obviously use they can use just administrative action, which is in terms of the Constitution, and only raise it only on the principle of legality.
Sorry, are you saying the organ of state can rely on Section 33 and legality?
No,
Because the constitutional right to just administrative action is Section 33 and PAJA, etc.
No, that has to do with PAJA, which they can't use, because
Okay,
the very
right.
decision that will be
Yes.
attacked on PAJA is the same. They
Yes.
would be the decision makers, so they can't use PAJA.
Okay,
So it will just be on the principle of legality
okay.
that the state can use.
All right, I think
Yeah.
let's leave it there. Thank you.
Yeah,
Thank you very much.
Sorry,
No, not at all.
all
Thank
over,
you.
my head is all over.
No, thank you. Thank you, Chief Justice.
Commissioner Barry?
Thank you, Chief Justice. Good morning, Ms. Magano.
Good morning, Commissioner.
Yes, you've given us 3 judgments, and it's a pity because they don't do you justice. I know you default to the one went to the SCA and it was upheld. That's the Top Street one.
Yes,
And
Top
then
Street.
Bwanya went to the Constitutional Court, it was upheld. But still,
But
one has to evaluate you on the basis of the judgments that you've written
Yes, ma'am.
to see your readiness. Now, the self-evident truth is that judges speak through their judgments. And in your case, as an applicant, your judgments I have never appeared before you, so I have only this interview and more importantly, your judgments to evaluate you on. Now, both judgments are in 2020.
That's correct.
The Top Street one. And it is it's a hard and painful judgment to read. I don't think it's unfair to say it's not a properly written judgment. I'm hoping that, when you say you are trainable, you have gone back and when you submitted it to us at least, you looked at the judgments and you identified that in 2024 maybe you are better than you were in 2020. And I wish you had given us the 2024 judgment. Now, on the 2020 judgments, and maybe here's where I ask for your comment. Is it not fair, would it not be fair to be concerned that if we were to recommend you on the basis of these or taking these judgments into account, we possibly are sending out a candidate who does require serious training, if we work off just these judgments? Do you want to comment on that? And maybe let me put it more positively this way, that they are a matter of concern for me, these judgments. And I'm, they don't convey clearly your reasoning, your thought process. You come to a decision, it may be the order is correct, but how you get there, how the reader of the judgment need to understand, especially the loser, need to understand why they lost. And it doesn't seem that your judgments, at least the Top Street one, doesn't seem to achieve that. Do you want to comment to that?
Thank you, Commissioner. Commissioner, the issue of the writing skill, as I don't want to repeat myself, it's something that I have tried to work on even outside of my acting stints, as I've indicated before to the Chief Justice. And it's said, it's really, I would have had, or at least given more of these judgments that I have written before. Perhaps I've chosen not the best. I do understand your concern. However, I would ask that you consider that my acting stints have run over intermittently over a period of years. And I am confident that with the extra writing skill that I've attained in being a chairperson of the two institutions that I've mentioned since 2020, I've had the opportunity to, which I could not obviously attach my awards because it relates to personal issues, employer-employee relations. I have done much better. Unfortunately, in this career, as a private counsel, you are not having the benefit of perhaps work with someone or someone work with you in upskilling or assisting you in empowering you more. But I have worked on it because I've identified that this is something that needs to be done. And I agree with you, Commissioner. One's obviously thought about a case as well as before reaching a decision must be understood by the recipients, especially those who are affected. So it is something that, as I've said, I'm so open that it be worked on with me, and I think with having the HAP has recognized that I have the potential. Going back to practice, still standing in the same position would perhaps be a discouragement, and no one is obliged, obviously, the Commission is not obliged to appoint, to recommend me, but I would ask that the Commission would give me that opportunity to be upskilled within, that is inside the Chief Justice Office as a candidate that is appointed or recommended.
Thank you. Thank you, Chief Justice.
Commissioner Ngqetho?
Thank you, Chief Justice. Advocate Magona, I just want to, because you see, when you gave answers to Commissioner Boshoff, I understand the second answer. It took a while, but you finally got the gist of it. So no problem there. But I couldn't understand your response to the first question in relation to whether a litigant who comes to court on an application for interim relief is entitled to rely only on the fact of the existence of a right to review that is codified in Section 33, or they have to show more under the outer principle. Could you just articulate a clear answer there?
Thank you, Commissioner. My answer is that they have to show for an interim interdict, the prima facie right, the irreparable harm, the balance of convenience, as well as no alternative remedy.
No.
Excuse me. No alternative remedy.
And I understand. I mean,
And when it comes to
yes.
the outer principles would be to to look if there's maybe issues of malafides or whatever, but there must be other further grounds that the court must look at.
No, I think the question is what type of a prima facie right they have to establish to satisfy the outer standard.
Let me just think clearly now.
Well, I mean, we can make an example. I made an example with the previous candidate. The JSC is conducting interview for your appointment. It is exercising a power directly derived from the Constitution.
Yes.
The political party wants to stop these processes because they believe that one commissioner should have been here but is not here. But they want interim relief. And you are now sitting as a judge, and you have to answer that question, and you have to apply the outer standard. What would the requirements be?
That there is an administrative action that is contravening your rights.
Now, I understand.
I'm sorry, Commissioner. Can you repeat that?
I'm saying, well, I just made an example.
Yes.
But it's still the same question of how you apply outer in practice. So the example I make is the JSC is conducting your interview to be appointed as a judge. A political party wants to bring an interim interdict against the JSC proceeding. The JSC is exercising a direct constitutional power. Outer deals with what a court must do when an organ of state is sought to be restrained from exercising power that is conferred on it by the Constitution. And it sets out the requirements for the interim relief. The question of Commissioner Boshoff is limited to the type of a prima facie right they must demonstrate in order to succeed. So, because he says often people think the mere fact that you have a right in the Constitution is enough, but the law says that's not enough. So what is enough to satisfy the standard? So you are now an acting judge and is coming before you, and you have to ask counsel for the applicant, address me on the outer requirements. What goes through your mind?
What prima facie right is being infringed here? I would ask the party. Why is it that you won't allow the interviews to take place whilst you are pursuing your interim, or rather, what right is being infringed that cannot be remedied at a later stage?
All right. Okay, let's move on from that. Maybe let me just ask a totally different question then on something you've dealt with. You spoke earlier about a judgment you gave which included mootness as a topic.
Yes.
Now, when you are sitting as a High Court judge and you find that a particular dispute is moot, do you have a discretion to deal with the merits in the interest of justice or not?
If you found that
Yes, you decide it's moot, it will have no practical effect. And then the applicant says, yes, my lady, even though it is moot, I would like you to deal with it in the interest of justice. And you're sitting as a High Court judge. Do you have that discretion to deal with the substance in the interest of justice?
I think you would, in the interest of justice.
You would?
I think you would, yes. If it is moot, it does not have an impact on the parties, but it might have an impact on the greater public. On the point itself might still have an impact to the public at large.
But isn't there an
The
SCA
issue.
judgment that specifically says the High Court does not have the discretion? It's only courts of appeal that have a discretion to decide moot cases. Now, let's move on from that. Just on the issues that, see, my difficulty is I'm trying to find a way in which I will assess your candidature and trying to ask a few legal questions so that I can be confident that you are ready to become a judge tomorrow.
Yes, thank you.
And that's what I'm struggling with at the moment. The Buanya judgment, I sort of read it, it's sort of all over the place, but ultimately it made its way to the South African law reports. So I wonder if you compared the judgment that you wrote and the judgment that was published, and so the corrections that were made by the editors.
I have compared a while back, and recently, that was when it was, recently when it was reported in 2021, I think.
Yes, but I'm saying if you start with your own and just do a mark-up and see that I committed 20 errors, they've been corrected by the editors. Did you do that exercise?
I did, Commissioner,
and then, what was the outcome?
And mine is to proceed in correcting that judgment.
I understand, but I'm saying what was the outcome of that comparison between yours and what the editors published?
Well, the outcome is yes, there were errors. I admitted to that. And I could see even now what I didn't want to do is to obviously now amend something that I've signed on. But I think the outcome to your question is that I saw that there were errors. Yes. There were typos, should have been diligent in checking the if I'm extracting something from another source, to make sure that it's clean. So I noticed that. And I appreciate, obviously, the issue of the structure. I did pick up as well. And when I compared to my notes that I had then when I was being trained by Sajay, especially in terms of structure. And that exercise sort of enlightened me that I should have done better, Commissioner. And hence, I thought I need to be writing a lot. Hence, I thought requesting and perhaps hoping to be invited at the time, but, doing the extra work that I've done when I was not invited as yet. So,
Yes.
yeah.
When we deliberate, you see, because so far it's only negative things that are emerging from, your CV, and so it's things that say do not recommend this candidate. But I'm looking for the positive things. I mean, what is the thing that you can leave us with that we should recommend you? Because so far the picture is not looking great from where I'm sitting.
Commissioner, I would highlight the rest of the criteria that is needed for a candidature of my nature in these kind of appointments. Commissioner, I would ask the commissioners to consider the fact that one is open to being trained. Commissioner, I would recommend the commissioners to consider the fact that my appointment would obviously perhaps encourage other Black African females to consider approaching the AJP or to consider acting, maybe whilst they are very young. Commissioner, I would recommend that the commissioners, when they look at me, to consider all my other attributes that I've achieved according to my application form. You must excuse me, Commissioner, for not completely recalling your substantive answers, because, as you know, sometimes as judges, we really just go through the rules as we go along drafting these judgments. You refresh yourself. What are the parties have said? What did the parties say to me? What are the heads of argument? What is the law on issues? But that is always, so dealing now with the questions here, and I appreciate that you made examples which were good, but I think the interview sometimes just gets to one that you're not thinking clearly. But certainly, I'm one who's willing to learn and to be upskilled and to subject myself to that.
Chief Justice, may I ask for a follow-up quickly? I mean, it's not this is one.
May I just point out that we are running an hour behind schedule now, so commissioners, before you raise your hand to put whatever follow-up or substantive question, just keep that in mind.
Yes. Thank you, Chief Justice. That's a follow-up. Look, Advocate, understanding you and the confidence you have, don't you think that at this stage you can just hold back, just take time to act so that you come forward? Because clearly you would like to be judged, and I can see from those structures, but you just need to polish yourself up. Don't you think that would be the best thing to do in view of all what has been said?
Commissioner, whenever that question comes, I think also from other candidates, it's always, or rather it leaves someone already feeling that, all right, the decision is made already. I would answer you this way, Commissioner.
The decision is not made already, Ms. Mr. Nokesi speaks only for himself.
Thank you.
There are 22 other people here.
Thank you, Chief Justice. I would think, Mr. Nokesi and the AJPs here, that sometimes, as you can see, since 2020, I couldn't get the opportunity. I did hear what the AJP is saying. Consider, Mr. Nokesi, that sometimes as a Black counsel, in this profession, number one, you go back to, yes, maybe acting, there's no guarantee, number one, that you're going to get it, or how the duration of it. Number two, you'll be running the risk, obviously, which has costed me in the past, of that it will cost your practice at the same time. So I would rather that this commission rather consider that this is someone who has the potential. From what I see, I hear from even from the AJP, if we do have someone who has that potential, rather than have them go back to something that we don't know, what might or might not happen, what is going to happen to her when she goes back? What are the potential of ever seeing this candidate again here? Maybe we'll lose them, be in between the cracks. I would rather request you consider that I be trained internally. This is just the element that needs to be corrected, or at least empowered in me, be upskilled internally, which AJP has said is something that is being done.
Commissioner Matolo-Dlepu.
A follow-up?
Commissioner Matolo-Dlepu.
Thank you, Chief Justice. Advocate Mahan, you know, I'm listening to you, and for me, it's the story for any black legal practitioner. And I'm wondering that if you are going to live here, firstly, where do you get your work? Does the state attorney or Mr. Boshoff give you work or whatever?
Certainly not Mr. Boshoff, to your example. State attorney only, Commissioner, and as I think I've said before, it comes maybe once in a quarter. You get paid in 30-something days, sometimes even later. So you have your 3 or 4 briefs only per year, and you suffer. You think, maybe I should leave, I shouldn't. Okay, let me try and do a little bit of another business or what. It's frustrating, and the work is only from the state attorney, to your question, Commissioner, which also is coming in pieces with all other challenges that come with it when it comes to payment.
Okay, thank you. I think Commissioner Boshoff is listening. So that at least from here.
Can I just clarify for the record? I'm in-house counsel. It's been made very clear to us that we have no line to the bar without the state attorney's intervention. So just to clarify that.
Well, I don't know what that's about, but thanks anyway. Commissioner Magena.
Good afternoon, Advocate.
Good afternoon, sir. Good afternoon, Commissioner.
You and I know each other.
I'm trying to recall.
Yes. Oh, if you
The
don't know
face
me,
is
it's
familiar.
fine.
The face is familiar, but I can't
Yes.
place.
Yes.
Parliament, perhaps?
Yes.
Please,
No.
you said
No.
you had a follow-up question, Commissioner Magena. May we have that follow-up question?
Yes. There is something that is worrying me regarding the statement that you said. You said you were not willing to apply for this post, and people came to you and encouraged you to apply, and that is why your application is not well prepared, and some of the judgments are not even attached here.
Not willing to apply is perhaps would have been a strong use of words. I was considering and put my decision here and there, tomorrow yes, the next day no. And when I heard colleagues were saying, you should do it, it's now. And then I thought maybe it is time.
Yeah.
Not being willing, no. There is a pool, once you start acting, Commissioner, your life is never the same. There is always a pull. The bench is like a magnet. You are practicing here, but whenever you go and appear in that court, you have something that is drawing you in it. So the dream and the vision in you is never dead. Whether I did it in last minutely or what, it's what I wanted to do.
And that's the thing. Following up from the questions posed by Advocate Baloyi there, regarding how we should assess your suitability based on the judgments that you have written, would you accept that this application was prepared haphazardly?
Haphazardly in what way?
In the sense that you did not have enough time to prepare for it, including finding judgments that you have written in the past.
I could not find them. I could not find them. I had no access to them. But time to write down and prepare, as you can see, typing the form, attaching the judgments. Yes, you can. I understand the challenges to the quality of the judgments, but there I had time, attaching the necessary forms. But what I couldn't find, Commissioner, if I was not understood, is my original signed judgment, because I only had drafts with me for various reasons. I, changed computers. I recall when I was typing then in 2015 to 2018, we were using Chief Justice laptops, which I had no access whenever I return. And yeah, so for various reasons, I couldn't find the judgments. And obviously, yes, the time was already there for me to having to submit something.
And you'd agree that if you are to step back, you would be afforded enough time to find those judgments, make them available to the Commission, so that your suitability can also be assessed based on your judgment writing skill?
I think, Commissioner, the judgment writing skill question I have answered. I think my suitability also must be considered on all the other requirements. I've answered the issue about my judgment writing skill. I would ask the Commissioner to consider, as I've stated, my, obviously, willingness to be upskilled internally, my willingness to opening myself up, basically, for training. I cannot give assurance that I will find the judgments. I'm sure some, I think after 5 years, I don't know, AJP can correct me, the files are destroyed. I might be wrong. All right, they're available. But I don't know if they will be. I can access them and find them. But yeah, to the upskilling and training, I would still go back to my answer that it would be done internally, please.
Thank you, Chief Justice.
Thank you.
Commissioner Malem? Commissioner Moiman?
I'm fine, CJ.
Commissioner Marumachai?
No, CJ, I will leave my questions. I'm fine.
You still want to have a go, Commissioner Lutyes?
Fine, thank you, Chief Justice.
Okay. All right. Thank you, Commissioners. Thank you. Ms. Magona?
Yes,
We've reached the end of your interview. Is there anything you want to raise with us before you go?
No, Chief Justice, I do appreciate the opportunity. Chief Justice, I hadn't congratulated you. I've never met you personally after your appointment also. I would want to just take the opportunity to congratulate you for your appointment as a Chief Justice.
Thank you.
It is encouraging and inspirational. Otherwise, there's no further questions from my side.
Thank you.
Thank you.
You're excused. Okay. What time is it? Got tea break, comfort break, as I call it.
Chief Justice, sorry to the commissioners. I apologize. This is something that's not usually
is
done.
it the candidate? Okay.
Yes, it's me still. Oh, one thing I wanted to your question, is there anything I wanted to say? It just comes to mind as I'm wrapping up. The commission to also just consider the comments from the various individuals, the various entities, which I do appreciate, that have also written their comments on my candidature. I would ask the commission to also consider those as they're making their mind about the suitable candidates.
We will do so.
Thank you.
Oh, now you've attracted an honors. JP Mlambo wants to ask you a question.
Good afternoon, Advocate Magona.
What have I done?
How are you?
I'm well, thanks, JP.
This is not part of the interview. I just need your guidance. I was listening to your experience as an acting judge and how you could not go ahead with, if I understood you well, with the Sajay program.
Yes.
Now, I just want to know whether you think it's viable to do what I'm going to suggest to you. What we did in Gauteng is we took all the Gauteng candidates and we made sure that every term we will invite them alternately to do a term, but the others who don't do it, only one does a term, the others share a term, that's 5 weeks, 5 weeks. And during that whole period, they are attached to senior permanent judges who are available to them at any given point in time. And the reason for that is that they don't lose touch with their practices, but they don't lose touch with the court. Do you think this is something that can work?
Internally, the thing about once you are taken out of your practice, this is what happens practically, JP. Practically, especially in the Western Cape, I don't know about Gauteng, once you are known to be someone who's on the bench, whether it's a term or alternative terms, the briefs don't come. The fear of the attorneys is the fact that you may not be available for that civil matter. I may need you now, I have to hire someone else, I have to spend so much money, and the briefs don't come. And incidentally, even now, since I've applied in June, I've received absolutely nothing. So it has its consequences. It sounds like a brilliant idea, but it has its consequences. Once you are in the bench, nothing comes your way.
Well,
Practice actually stops and dies.
Yeah, well, probably that may be a Cape dynamic because
Yeah.
the candidates appreciate that
Yeah.
fact that they still have a foot in their practices. And they actually engage me as to how to structure their acting times to factor in what they're doing in their practices.
Yes, JP.
And that seems to be working. So I was just asking if you think it's something that could have traction here, but you seem to suggest there's a different dynamic.
There's a different dynamic. That's a dynamic. It sounds like a brilliant one, but there's just something that happens once you are on the bench, or sometimes now and then you go there, nothing happens. Nothing flows your way. You are completely dependent on what you are getting from Sajay. I don't know if you're talking about pro bono on pro bono basis, JP?
No.
Oh, you get paid.
Stipendiary.
So nothing flows your way at all in your practice. Your practice dies. That's a practice, what happens here. And I've experienced it over the years since I've acted, which has killed my practice. And that's just another story as well.
You must relocate to Gauteng. Thank you, CJ.
Thank you.
Thank you, JP, and thank you, Ms. Magona.